Right, so learning unit 4 time, trusts. Now, remember we talked a little bit about trusts earlier and that they can sometimes be a legal entity for certain acts. They can be a legal personality, they can be contract, blah, blah, blah. So trusts are the exception rather than the rule for a lot of things. So what do we know about trusts? So a trust is a legal relationship created by a trust deed. There are three parties involved in a trust. Number one, you've got your founder. He is the oak that makes it. He's also called your donor or your settler. He puts assets under the control of another person, a trustee, for the benefit of person number three, who is the beneficiary. A trustee can also be a beneficiary. That creates quite a few problems. We are going to talk about that in a little bit. Because the roles cannot be confused. Now, what is the act that controls trusts? Remember, we've done a Closed Corporations Act, we've done a Companies Act. Act that controls trusts is called the Trust Property Control Act. By the way, if the lights go off, it's load shedding. I do apologize. Okay, so what are the 6 points? There's 6 steps to creating a valid trust. Number one, there must be intent to create the trust. The founder says, okay, I want to create a trust. Then he must express that intention to the trustees, either through a will or through a deed of trust or through a contract. So that's number one. There must be the intention that is expressed by the founder. Number two, there goes load shedding. The object of the trust must be lawful. So it must be there to do something that is lawful. So you can't use a trust to smuggle drugs. Well, you're not legally allowed to anyway. Number three, the trust property must be defined with certainty. So the founder must say, I give the trust my property at 22 Church Street, Cape Town, 8,000. I give the trust the sum of 100,000 Rand. I give the trust my Xbox 360, etc., etc. So it must be defined. Number four, the objectives of the trust must be certain. So not only must it be lawful, but it must not be uncertain. So you can't go, I gooi all this stuff into the trust. Now what must the trust do with it? He must say, I wanted to run as a business trust, or I wanted to protect the assets for future generations of the family, or I wanted to create income for future generations of the family. So far, there must be an expressed intention either in a will or in a contract or a deed of trust. Number two, we must be doing something that is lawful. Number three, the trust property must be defined with certainty. Make it clear what you are giving to the trust. Number four, the object of the trust must be the objectives of the trust must be sufficiently certain. You must know what the trust is being set up for. Number five, there must be beneficiaries, because if there are no beneficiaries, there's no trust. Number six, there must be at least one trustee, because if there's not at least one trustee, hey presto, we got a problem. There's no trust either. So let's go through it again. Must be intention, must be lawful. You must know what the trust is doing, what it is there for. What property does the trust own? There must be beneficiaries, because if there's no beneficiaries, there's no trust. There is also must be at least one trustee. If there's not at least one trustee, there's no trust. And trustees are appointed by the Master of the High Court. So the Trust Property Control Act allows for two types of trust. Now, remember last time when we were talking about trust, there was a little bit of confusion about the different types of trust and the way to form a trust. So there are two ways to form a trust. Number one, by a will and testament, which means it comes into effect on the death of the founder. Number two is an inter vivos trust, which means that a trust created inter vivos, which means it is created by a contract when the founder is still alive. So those are the two ways to create a trust. Now, the two types of trust, you get an ordinary trust where the trustees have non-beneficial ownership of the assets. So they own and control the assets. You also get a bewind trust where the beneficiary has ownership of the assets but does not have control over them. That usually happens in the case of minors that are left property. So if you are left property by your grandmother, if you left a house worth 6.5 million rand by your grandmother and you are 16 years old, you own the house, yes, but you do not have control over the house. That is left to trustees. So ordinary trust, bewind trust. Why do people create trusts? Let's just talk about that. People create trusts to make it easier to plan their estates. When you leave assets to the next generation, they are taxed for every generation that goes past. However, if you do it in a trust, if you put those assets in a trust, you avoid that inheritance tax. Because remember, unless specified, a trust is seen as being perpetual. Or unless somebody fucks up and the trust is wound up. Trust is perpetual. So number one is for estate planning purposes. Avoid an inheritance tax. Make the relative's job easier. Number two, it's for asset protection. If you are in a risky business and the business has a chance of going under, you don't want to lose your house. You don't want to lose your nice R1 million car. So you put them in a trust. So even if you go under, the trust will not go under and you can still maintain the use, if not the ownership, of those assets. Number three, and the third one is the most important because that's the one we're going to be talking about. That is business purposes. A trust can be run like a business. Now, a business trust is not the third type of trust. You still only get ordinary trusts and bewind trusts. But a business trust is an ordinary trust in which the trustees have been given power to carry on a business or to carry on trade. That's the most important thing. It is a normal trust, but where the trustees have been given more power. The trust deed allows the trust to resemble a company in that the trustees can act like directors and the beneficiaries act like shareholders. So, as we've said, we can create the trust in two ways. Either by contract, which means it's an inter vivos trust, which means you have to follow the laws of contract. That's common law and also any prescribed legislation. Or you can create it in your will and testament. The testator will create it in their will and testament, which means that you've got to follow the criteria that the Wills Act prescribes. If you do not follow that criteria, sorry, you got nothing. Right. So let's talk about family trusts versus business trusts. Whatever you call them, they are still ordinary trusts. That main definition does not change. The difference between the two is the rights that are given to the beneficiaries. Family trusts give fewer powers to the trustees. And you can't just say, hey, I want to get out of here. I'm going to give my rights as a beneficiary to someone else. In a business trust, if you are a beneficiary, you can sell or transfer your right as a trustee, as a beneficiary rather, to someone else, because of the way that the deed of trust allows. You can't do that for a family trust. A perfect example of a business trust is someone like Coronation. Alan Gray is a business trust. When you invest 5,000 Rand or 10,000 Rand into Coronation, you are not investing, you are buying the right to become a beneficiary in their trust. That's not the same idea as if you and your booty and your sissy and your mom and your auntie and your uncle are in a family trust which lets you use the family house. You can't just say, "Hey, no, I don't want to be a beneficiary anymore. I'm going to sell my right as a beneficiary to somebody down the road." Okay. So what is the difference between a private business trust and a public business trust? Okay. Now, there are certain rights. In a public business trust, the public are invited to become beneficiaries if they pay money or assets. The example that we just used was Coronation. They're invited to become beneficiaries if they give money or assets. So you put in your 5,000 Rand, you put in your 10,000 Rand, you become a beneficiary. If you are in a private trust, private business trust, you are probably just an entrepreneur who is using that business trust as a vehicle to carry out your business, because it is easier than a company. It is easier than many of the other structures, but you're still carrying out a business. You're just using the vehicle of a trust to do it. So that is the difference. But remember, whatever you call them, they are still ordinary trusts. The B1 trusts are the exception. Okay, so now, they will probably ask you this. What are the 8 duties of a trustee? Number 1, fiduciary duty. Be a lacquer O, be an honest O. Don't run away with the money. Number 2, act with care and skill. Don't act unreasonably. Don't make stupid impulsive decisions. Consider every decision. Think, what will this do for the business? What will it do for the bottom line? Etc., etc., etc. So fiduciary duty, duty of care and skill. Number 3, open a trust bank account. You can't so much as gooi the money of the trust into a trustee's bank account. You can't. You have got to have a separate trust account. Usually that is done by an attorney. You also have to have a record at all times of the trust's property. Always. Number 4, you have got to always account to the master. When I say the master, I mean the master of the High Court. And to the beneficiaries. You've got to tell them what you're doing at all times. And if you have fucked up in some way, shape, or form, then you have got to explain. You've got to explain what you're doing, what you're doing, why you're doing it, why it's good for the business. If you did wrong, then you've got to explain that as well. Number 5, act with the utmost good faith. So that is over and above a fiduciary duty. Be completely honest, even more so than you would be if you were running a company. You've got to, because that is the nature of a trust. It's a legal arrangement based on trust. Company, you might not even trust each other. Number 6, act with independent discretion. So if you as a trustee have to make a decision, don't just make a decision because that's what the other trustees are saying. You have to make a decision based on what your own opinion is, what your value judgment is. Number 7, invest assets productively. Business trusts are different because they are other ordinary trusts. You cannot really dabble around with the assets too much. Business trusts, you can speculate a bit, but do it in a way that is productive, that is going to make money. Don't just go blow it in your brother's casino. Number 8, act in terms of the trust deed. You always have to do that. You cannot not act in terms of the trust deed. Right. So what are the 8? Number 1 is a fiduciary duty. Number 2, you've got to act with care, diligence, and skill. Number 3, you've got to open a trust bank account, keep records of the trust's property. Number 4, you've got to account to the master and to the beneficiaries. Number 5, you've got to act with good faith. Number 6, you've got to, not only good faith, but the utmost good faith. Let's use our adjectives lacquer. Number 6 rather, you've got to exercise independent discretion. Make decisions because you believe that that's the right decision to make, not because you are being told that that is the right decision to make. Number 7, invest assets productively. Don't blow it if you can help it. Number 8, act in terms of the trust deed. The trust deed will tell you what to do, and just do that. It's not that hard. Right, so what are the rights of beneficiaries? Trust Property Control Act, which is the act that we're dealing with here, says that beneficiaries have certain rights and duties. If the trust deed allows it, now business trusts, you can cede or transfer your right as a beneficiary. Most other times you can't. Beneficiaries, by and large, have 2 rights. They have vested rights and they have discretionary rights. Vested rights mean that they belong to you no matter what the trustees say. The law, the Trust Property Control Act, says you've got them. And discretionary rights mean that the trustees do have a little bit of control over as to what happens to those rights. So, for example, an example of a vested right will say, if the trust deed says Johnny, the beneficiary, has right to income from the trust, if that's all it says, that is a vested right. So the trustees have got to give him income. They've got to pay him something as a beneficiary. But a discretionary right would be the amount of income he's given. So let's say the trust makes 10 million rand in profit for the year. The trustees don't necessarily have to give Johnny that full 10 million. They can choose to give him 5 million. They can choose to give him 1 rand. If his only vested right is that he has the right to income, then the discretionary right, if the vested right is that he has the right to income, then the discretionary right is how much he gets. So vested rights you cannot take away, or you can't mess with. Discretionary rights you can mess with a little bit. But the important thing to remember is that a business trust is not its own form of trust. It is a type of ordinary trust. It is a special type of ordinary trust. A B wine trust is not an ordinary trust because the beneficiaries have ownership, but the trustees have control. Ordinary trustees have non-beneficial ownership and control. 2 types of trust. The big thing I want you to take out of this is a couple of things. Number one, we're dealing with the Trust Property Control Act. Number two, there are two ways to create a trust. Either the inter vivos way, which means through contract, or the testamentary way, which is through the will. Okay, so those are the two ways. The two types of trust are an ordinary trust and a B1 trust, and a business trust is a type of ordinary trust. And that is Learning Unit 4.